I'm Ron Zimmett. I'm a Florida trial lawyer and risk management consultant for many years to Negley Associates. This is the ongoing series of our monthly risk management tips for behavioral health care providers. I've got two pretty important questions for you today. First, do you still think there's a duty to warn? Second, do you know what your state law requires you to do if you think your patient is dangerous and could commit a violent act in the near future? Here's an example of a perplexing case which points out the difficulty of knowing what the right thing is when you have a violent patient. In Utah, a therapist asked the police for assistance transporting a suicidal patient to a secure psychiatric unit. The therapist knew the patient had a history of threatening violent behavior and had sometimes waved a gun around at home threatening his family and himself. The therapist also knew that the patient sometimes had a gun in his truck and asked him if he had a weapon. The patient was not very forthcoming and said, "Maybe I do and maybe I don't." The therapist told the police dispatcher that the patient did not have any weapons. Well, when the policeman tried to take the patient to the secure unit, the patient put up a fight, and during the fight, a handgun hidden in the patient's pocket discharged, and the officer was shot in the foot. Now, the seemingly comforting thing for the therapist was that the Utah Code provided that the therapist did not have a duty to warn or take precautions to provide protection from violent behavior of a client, except when the patient communicated to the therapist an actual threat of physical violence against a clearly identified or reasonably identifiable victim. The statute's comforting because the patient did not communicate to the therapist any actual threat of violence to the police officer. Thus, you would think the courts would simply rule that the therapist was not liable, and that would be the end of it. However, it did not turn out that way. The court ruled, despite the fact that the statute did not require a warning, the therapist nonetheless had a duty to exercise reasonable care when she responded to the police dispatcher's question of whether the patient had any weapons. Thus, the therapist could be liable for the injury to the police officer even if the statute provided she had no duty to warn. Actually, there is no duty to warn. It's a misleading term because the duty is a duty to protect and to take reasonable precautions under the circumstances to protect people who may be in danger from patients. A warning might be the worst thing a therapist could do because the person warned might escalate the conflict. You have to take the unique circumstances into account. It's particularly important that you become very, very familiar with what your specific state law is and what it requires you to do when you have a potentially violent patient. It varies widely from state to state. And sometimes even in the state, it varies even from one particular discipline to another, so that a social worker might have a different responsibility than a psychiatrist. So there it is, a perplexing case, a couple of questions, pretty important, and our risk management tip for this month. Thanks for listening. I'm Ron Zimmett.